Okay, then let's proceed to argument. Go ahead, Mr. Stover.
Thank you, Your Honor. Your Honor, in this case, the state has testimony from an eyewitness who observed the defendant to place his hand around the neck of a 5-month-old child and strangle him. Those are the words of the witness and what she saw. So frightened was she that before this she wasn't frightened by the defendant, but immediately after was very scared of him. The defendant's statement changes from time to time that he went in, and in fact, his statement to officers that we heard today was that after leaving for a time and coming back, that he went in and checked on his son, and his son was okay. This places him as the person who is in the room with JoJo last. May I retrieve the exhibit, Your Honor?
Yes.
The court also heard testimony from that same witness that she observed JoJo the day before, and he was not in any distress or injured. And yet, the court heard from the office of the medical investigator, Mr. Jones, that this is the neck of the baby, Joseph. That's State's Exhibit 4. State's Exhibit 5, the back of Joseph. These photographs are directly consistent with what the witness testified to, as described again also by Agent Aguilar, holding the back of the child, where we see the marks towards the shoulder and up, and then in State's Exhibit 4, the marks around the baby's neck. The baby is then left inside the room. The court saw the condition of the room, and the child is left in that room from the very early morning hours until around 2 o'clock, when the witness, Ms. Jasper, walks by, notices now the condition of the baby, calls out to the defendant. The defendant did everything he could to try and set it up for Jasper to be the one to take the fall, even leaving and then coming back. But in the end, he's the one who placed his arms around this child, ending the child's life. In addition, Your Honor, the testimony is that he brings a 2-year-old daughter home, and from 6 o'clock in the evening until 1 o'clock the next day, she is left in a room. The court saw the condition of the room. The court saw the insect infestation in the home and the feces and the condition of the bed. I would submit to the court that confining a child in a space such as that for this period of time, one, places the child in a situation that could endanger the child's health or safety, but also is cruelly confining the child. And that, so we are asking the court to bind this matter to the district court on 1 count of child abuse resulting in death and 1 count of child abuse. Thank you.
Okay, thank you, Mr. Shieldgen.
Thank you, Judge. I guess I'm not clear, Judge. Are they asking the court to bind it over on reckless child abuse or intentional child abuse?
Well, Mr. Stover, what's your specific charge that you were seeking to
We're
have this
seeking
court bind
intentional
over?
child abuse resulting in death.
Okay.
Well, Judge, unfortunately for them, in order to get to intentional child abuse resulting in death, they would have to have some testimony that states that this child died as a result of some form of asphyxiation. They haven't done that. It would also would also have to present some evidence that it was intentional asphyxiation and not something like positional asphyxiation, which is something that is actually quite common, that happens with children that are sitting in child seats or sleepers. Very similar to this, very similar to both versions of events that Jasper and Jared tell the police. She testified that Jared never told her what to say, and they never concocted a plan together, but yet they both have the same version of events. She only changes her story after she's lied to by a detective in this case, or someone with law enforcement authority, an agent of the prosecutor, I guess. If he's a detective at the prosecutor's office, he's lied to by an agent of the individual here, now asking you to bind it over on first-degree intentional child abuse, a life offense. She's lied to about it, and then she changes her story. Her versions of events are fantastical. And so one of the objects of a preliminary exam, and again, I'm not trying to tell the court anything I know that the court knows, but I just want to make a record of it. This is a filtering process where the court can determine credibility at these early stages to filter out unjust cases going forward. And so what the government is asking you to do today is to say, not only do we not have to give you cause of death, manner of death, or any testimony regarding how this baby died, all we have to do is put up a fantastical witness who is lied to by investigators on multiple occasions until she changed her story and then created a new story. And then, by the way, we don't have to give you any medical testimony. We don't have to tell you that the medical examiner, through a medical examiner, that the markings around the neck are consistent with a hand. I mean, the court has the photos. There's nothing there that looks like fingerprints regarding a strangulation. We heard no testimony, Judge, regarding how or why, it's not showing up on the Elmo, very good, Judge, but how or why.
You can zoom it out if you need to.
How or why, I'm not an expert at this, Judge. I'll move on. We have no idea how or why a child like this exhibits those conditions. I know from experience, I'm assuming the court does too, that when people pass away, blood pools in certain areas of the body, and that's one way they can make a guess as to how somebody was positioned at death or shortly after death. That, to me, is what this looks like. These are just markings of blood pooling after the heart stops pumping. Now, unfortunately, they presented no testimony as to what they are. They just want to say, Judge, look, and I'm not trying to make light of the situation of this child. I have a 2-year-old daughter myself. The pictures look terrible, but the court has no frame of reference as to what this means. Are these the results of abusive conduct, of intentional conduct, or is this simply the way that a child who falls out of a sleeper into an awkward position, their neck would lay like this, blood would pool in that area after the heart stops pumping, and then the rest of these, I'm not calling them injuries, the rest of this blood pooling would occur as a result of that position. They've presented no testimony as to what that is. There's no testimony, any of these injuries to this child, Judge. If they're injuries, the court cannot conclude that. The court just has to simply say this individual, this young child, is deceased, and it looks terrible. And that's the case. It would be at any time somebody passes away, it's going to look terrible. There's no information, there's no content there for the court to make a decision. Now, had they called the medical examiner to give the court the cause of death, the manner of death, and testify as to the nature of these injuries and how they could have occurred, then I would have been able to cross-examine them, Judge, on whether or not the body was rigid. How quick does rigor mortis set in a child? Is it quicker than an adult? I believe it is. That's not in evidence right now because we heard no medical testimony. The way that rigor mortis works, Judge, is how the muscles release certain chemicals that cause them to stiffen on their own. We heard no testimony regarding that. Does it happen slower or faster when it's a 5-month-old? We heard nothing regarding that. Does it release faster when it's a 5-month-old? Are there underlying conditions that can affect whether or not it sets in faster or later? We heard nothing regarding that. And if we had, it's just as likely that the condition of this child matched what Jared told the police and what Audrey told the police. Only confronted with lies and threats of a crime did she then change her story and say, no, actually I saw Jared. And then, by the way, I saw Jared do this, and then I was so afraid I just hung around the house and palled around with him on the couch, and another friend came over who was also present. We heard nothing about what that gentleman had to say. She never could make a phone call, but she could, or text anybody, but she could peruse Facebook. All the while she knows, oh, I watched this child get strangled. And I don't know if there's some meaning as to why they wouldn't produce the medical examiner here to tell the court. My mind that challenges everybody's motives would tell me if it was something positive, they would have just produced them. I would say it's very common for medical examiners to testify in murder cases at the preliminary exam in New Mexico, Judge. I've cross-examined them many times at this early stage. So unlike a very sound argument the court made regarding discovery at this stage, that doesn't prevent them from taking testimony. Maybe the medical examiner doesn't have a report, etc. But she certainly can come here, or he can certainly come here and give us his medical opinion as to how this child died. And so, since the function of this hearing is a screening process to prevent unjust cases going forward, I would challenge anybody to say that they've given probable cause that this child died as a result of intentional conduct. There's been no evidence of that other than the very suspicious and untrustworthy statement of this woman, Jasper. We heard from the detective. I made sure to say it in the right way so that I wasn't letting them know where I was going. Hey, was she exhibiting a panic attack or anything that you would describe as unusual when she changed her story? No, but that's what she said, that she was so afraid she didn't know what to do. No, it was only when confronted with lies and threats that she then changed her story. Now, my argument would be completely different, Judge, and I'm not repeating myself, but I want to make it clear. My argument would now be different if they presented medical evidence that corroborated what she says. Now this argument would have to be different, but the court doesn't have that before them. So the court, just to be clear, the court doesn't have cause of death, manner of death, both of things which are the law. It requires medical examiners to make claims regarding. It doesn't have any evidence regarding time of death, cause of death. They've presented nothing regarding motive, Judge. Now, they didn't charge this as a first-degree motive case, but they are charging it as intentional. They provided nothing regarding motive. Now, I know they don't have to say motive, but it certainly helps the court, gives color. All we heard is that Jared's never threatened his child or hurt his child, and she actually told, until threatened and lied to, she told investigators that she didn't believe he would ever hurt his child. So there's no cause of death, no manner of death. There's no evidence regarding whether or not this was intentional conduct. There's no motive. These photos could be just as consistent with an accidental death, some version of, we call it co-sleeping, where a child falls into an unhealthy position and can't remove itself, and they pass away. And that is exactly what Jared and Jasper first told the police. I would say the condition of the house is troubling regarding the other child abuse count, Judge. I don't know that simply disagreeing with the way somebody lives is evidence of child abuse. I would say most of the third world lives. My wife's from Bangladesh. Didn't get here until she was 14. She had dirt floors and lived in a hut. That's how almost everybody that she knows in Bangladesh lives. Most of the third world lives with bugs, lice, problems that in this world we don't have to deal with. I don't know that it's evidence of child abuse. It's certainly not evidence of intentional child abuse. I would also add that Jared has a debilitating disease. He has issues using his hands and legs, as the courts watched him walk back and forth with assistance from the deputies. He has people coming several times a week, 4 or 5 times a week, at several hours at a time to assist him. That may be one reason why the house is in a state of disarray, and not the result of intentional child abuse. So, Judge, frankly, I'm frustrated, and I approached the prosecutor ahead of time. I said, I think you need medical evidence in order for us to go forward. They're under the belief that they don't need any medical evidence. I would say in a case where you're going to accuse somebody of a life offense in New Mexico, you have to present some medical evidence that shows that how this child died. I would think it's highly improper at this point for the court to go forward with what is essentially a first-degree murder case on a 5-month-old child with no medical evidence that this was a result of intentional conduct. The child abuse regarding the daughter probably is a closer call, just because I can understand the emotional content of the photos, but they still haven't presented any real evidence that how or why that is child abuse. They just want to say, well, Judge, look at how this poor gentleman with cerebral palsy lives. He must be an abuser. So I find it highly suspect that this, at some point, a motion to quash bindover would be appropriate. And I don't take that lightly. I really don't, Judge. So at this point, I'd be asking the court to not bind it over, certainly on first-degree child abuse. If they were simply arguing reckless, first-degree child abuse as a result of recklessness, maybe it would be harder to make that argument, because then they would be arguing potentially, well, how the child was found, even if it wasn't intentional, blah, blah, blah. That would be a more reasonable argument for them to be making. First-degree child abuse is almost an instant motion to quash bindover as soon as we get out of here. Thank you, Judge.
Mr. Stover.
Thank you, Your Honor. Very interesting in this case. If we're going to go off the evidence from the stand, which is what we have to, and not the wonderful expert testimony defense counsel attempted to provide the court, telling the court what Rigger did or didn't mean, the number of other times he's cross-examined and who he hasn't talked to, none of that is evidence. So let's take a look at what the evidence is. Judge, if I came before you and I said that there were 2 adults in the house, and one person saw an adult strangling the other adult, and then the second adult was found dead, is it probable that the first adult killed the second one? Would it be probable? Yes. So why all of a sudden when it's a child, we entertain all of these miracles and wonders about, it could have happened this way or it could have happened that way. The court sees the photographs of this child, the injury to his ankle, the injury to his wrist, bleeding. These aren't pooling of blood. The injuries on his back and on his neck, exactly where we would expect to find them if what our eyewitness saw actually occurred. And remember, defense counsel's the one who brought this out with Officer Aguilar. Well, this was after you showed her pictures. I never showed her pictures. She didn't see those pictures. She just guessed and got it that right? No, she didn't guess. She told the court what she saw. Intentional? Yes. When you hold the baby, placing your hand over their throat and strangle them, that is intentionally abusing the child. That's not reckless. That's not accidental anymore. And then how did the defendant behave after that? Lie after lie after lie after lie. Oh, I went in and checked on the baby. Oh, I changed the baby. Oh, I did this. He didn't do any of those things. Said he fed the baby. There wasn't a clean bottle in the house. Not one found in the house. One found on the floor with a roach in it. The other one with crusted, molded material on it. So the defendant is not telling the truth. Defense counsel questions the credibility of the witness, Ms. Jasper. And certainly, Ms. Jasper did not behave the way that we would want someone to behave when they see a defendant killing a child with his bare hands. She didn't. And defense counsel talks about the fact that she only changed her story to tell what happened, tell what she saw when she was lied to. What was she lied about? Do you recall? Agent Aguilar said, Jared wants you to tell the truth. Not Jared said, Jared wants you to tell the truth. And then she said what she saw. She didn't hate this individual. She didn't have an axe to grind against him. She was there to help him. And so she tells the court what she sees, him strangling his own child with his bare hands and then leaving that child. Now, it is true, there are places in the world where people will live on dirt huts. They don't have to live in filth. Doesn't matter if it's a dirt hut or not. They don't have to live infested with roaches, and they certainly don't have to be shut in a room all day with those conditions. And that's what the defendant also did. Locked in this house, in this room, in this bedroom, in that filth that whole time? Was that reckless, or was that an intentional act by him when he does that and then goes out and hangs out with his friends? I submit to the court, in this case, it is probable, based upon the evidence and the testimony received in this court, that the defendant intentionally inflicted child abuse resulting in the death of Joseph White, and that he intentionally confining her and placing her in a situation that could endanger her health or safety. And I would ask the court to bind the matter to the district court.
All right, thank you, counsel. Well, based on the evidence that has been presented in this preliminary examination and a review of that evidence, this court will find that there is probable cause to believe that the charged offenses were committed and that the defendant committed the offenses. Therefore, it's ordered that the defendant be bound over for trial in the district court as to count 1, child abuse resulting in death, and count 2, abuse of a child. I will draft the order on that preliminary examination, and the state has also filed in conjunction I believe a petition to hold the defendant in pretrial detention. Mr. Stover, are you ready to proceed on that?
We are prepared to proceed on that as well.
Mr. Shieldgen?
Yes, Judge, thank you.
All right, you may proceed.
Your Honor, I don't intend to go back over the evidence that has previously been presented in the preliminary hearing. I will state to the court that I have reviewed the defendant's history, both in his III and in reviewing New Mexico courts and other sources. The defendant doesn't have any other criminal history. I'm not here to present any other criminal history with regard to the defendant. And I'm not going to argue that there is some out there. We have checked and there isn't any. Our argument simply is this, Your Honor. Twofold. One, the defendant had been there the day before and then came back into town on the 19th before the 20th, according to the testimony. A man who would treat his own children in this way, what condition of release will this court give that he would reasonably obey? I would submit to the court he is a danger to the community and would ask that he be remanded in preventative detention. Would ask the court to set this for an expedited trial setting.
Thank you, Mr. Shieldgen.
Thank you, Judge. I would note, Judge, that the last part of the government's case is hinging on, well, a man that would do this to his child. Jared's presumed innocent. The court said nothing about his guilt or innocence. The court merely listened to the evidence and merely ruled that there was probable cause in the court's opinion so that the case can go forward. It has nothing to do with whether or not the court believes Jared did this to his child, quote unquote. And that is one of the factors that the court can use to determine the pretrial detention, is the strength of the evidence. And simply because the court bound it over doesn't mean, well, my God, I can't believe he did this to his child. All the court can say is, well, the accusation is there, and because we have the testimony of this Jasper woman, that's probable cause, which is probably a fair, probably a fair thing for in the court's position. You say, yeah, I can probably find probable cause there because she's saying it. That's probable cause. That's not a determination that it's strong evidence. The court heard her testify. I would say that it's shaky as best, her evidence. And moreover, Judge, I would go back to this idea regarding the credibility of the witness and then the strength of the evidence, which is one of the factors the court uses to determine the pretrial detention, is that this woman only changed her story after she was lied to and manipulated by the prosecutor's investigator. And the reason that's important, Judge, is because the prosecutor said, well, what did she change her lie to? Well, it's because the detective has not turned over the discovery, so I can't cross-examine him or review the video to determine, is that when she changed her story? Is that what was said to her? And frankly, Judge, it should be suspicious anytime somebody says that they told multiple lies to somebody to get them to change their story. The court should be suspicious of anything that comes out of that witness's mouth. And that has nothing to do with this individual personally. I'm saying that's how we all work as lawyers in this world. Once somebody admits that they lie, it's difficult to believe them about anything. And that's true of Jasper and then, unfortunately, the investigator. I would note, Judge, that the professionals, I believe the people that the court pay, stated that Jared should be released ROR. I have that here too, Judge. I'm sure the court has the copy of it. I'm pulling it up now, Judge. This was the pretrial services report. Looks like it's dated 7/21, Judge. It's 1-in-1 ROR. So the least possible way to manage to scale out all of the factors that they use, they say ROR. It's not ROR 2-1 or ROR 2-2. Any of the four possible RORs is 1-in-1. They're saying lowest likelihood of him not showing up to court. They say he should just be released. And these are the professional people that do that for probably every criminal case in this county. That would be my guess. And they know what the offense is, they know what all the factors are, and they say he should be released. One of the reasons they say that is because of the criminal history. He's 37 or 38 with no prior criminal history. I'm sorry, 35 with no prior criminal history. The best way to predict the future is based on the past, and he's got 35 years of obviously comporting his conduct with the dictates of society because he has no prior criminal history, Judge. They didn't even elicit a speeding ticket or anything else. So that says the 99.9% of the years or minutes of this man's life, he's conducted himself in accordance with society. That would be a factor that should heavily weigh in favor of release. Another thing is, Judge, individuals are presumed to follow court's orders. And if it can't just be based on theory or speculation. If we don't presume that people follow court's orders, which is a basic premise in criminal law, orders are essentially ineffective. It makes no sense to have a system where a court gives orders to individuals. So one of the things the courts would be doing would say, Jared, we know that you have constant medical needs, you have cerebral palsy. I'm going to order you to go to your treatment, go to see your doctor, stay in touch with your lawyer, comply with all the commands of the court, not hang around with felons, not engage in any new criminal conduct. And his past tells the court that he would comply with those orders. So the basic premise is that people are presumed to follow the court's orders. That's why this state changed its law, and we're going to allow people to be out because they're presumed innocent, and because we assume people will follow court's orders, and it's unjust to hold them if we don't have to. And so here they're relying almost solely on the nature of the offense. And the case law is pretty clear that that's a factor, but that can't be the sole factor that's used. I would argue the randomness is probably would be a bigger concern if the conduct was randomly engaging in violent criminal conduct throughout the county or throughout the state. You'd say, wow, we just don't know if we can trust this guy. But this is a highly isolated incident based on the court. I respect the court's ruling based on very minimal probable cause, not some slam dunk case for them. So for those reasons, Judge, the ROR, the professionals that have interviewed him and determined that he should be released, this state's strong and consistent policy on releasing individuals prior to trial because they're presumed innocent, and then the very minimal probable cause presented that solely hinges on the testimony of two individuals who have admitted that they lied. Thank you, Judge.
Thank you. Mr. Stover, do you have anything else?
Just very briefly. Again, so when the professionals put together their form, as they oftentimes do, these are individuals who are tasked with looking at a variety of factors. And so there's one factor that they consider when it comes to the offense. They say, current violent offense. That's it. That's the only consideration that they make with regard to the offense. And it is true that the court cannot just say, well, someone is accused of a first-degree felony and so they get help. That's absolutely, completely true. No question about it. But for this evaluation document, is it violent or not? That's one point, and the only thing they look at. That means that they don't look at the factors within the offense itself. It would be the equivalent of saying that an aggravated assault where someone throws a big rock at somebody, which is an aggravated assault, which is a fourth-degree felony and a violent offense, is equivalent functionally to what happened here, the strangulation of a child. Those two things are not functionally equivalent. On this assessment device, they are. The defense says we presume that people will obey the orders of the court. We also presume people will treat their children a certain way. The defendant has demonstrated he won't follow that aspect of society and what society expects of us. Why then do we think he's going to now obey what the court has ordered him to do? Thank you, Judge.
All right, thank you. Well, as counsel know, in order for me to hold an individual on pretrial detention, I have to find that that individual is, number one, dangerous, and number two, that there are no conditions of release that exist that would reasonably protect the safety of the community or another. So addressing the first factor as to the dangerousness of the defendant in this matter, obviously this court has bound over two charges: one, first-degree child abuse resulting in death, and third-degree child abuse. And given the allegations surrounding what's been presented in the preliminary examination involving the defendant allegedly holding a 5-month-old child by his neck, and the inconsistent statements and the manner in which the reaction time or no reaction time between the incident and when law enforcement's called, I have to find that he is, number one, dangerous, just based on the nature of the charges. Now, moving on to whether or not there are conditions of release that exist that would reasonably protect the safety of the community. It was brought up to me that he has no criminal history whatsoever, and So there's no history on criminal activity or any failure to appears, any flight risk aspect, anything of that he would not abide by conditions of release. So I cannot hold Mr. White on pretrial detention. However, his bond will be in the amount of $25,000 cash or 10%. So his conditions of release are that he cannot leave Curry or Roosevelt County. He will be placed on house arrest with an ankle monitor if available. House arrest means that he can go seek medical attention, and he can speak with his attorney, but he must remain in Curry and Roosevelt County. He must not possess any dangerous weapons at any time. He must not possess any illicit drugs. And he must not have any contact with any minor children whatsoever while this matter is pending. Other conditions of release, Mr. Stover, that you want imposed?
Your Honor, we would ask, of course, that he be required not to make contact with any of the witnesses who may testify in this case. Of course, his attorney is welcome to contact witnesses, but we're asking that he not. And then we are requesting that the defendant abstain from the use of alcohol or marijuana products unless the marijuana or cannabis is prescribed to him by a physician.
Okay, Mr. Shieldgen, do you have any objections?
I would say no, Judge.
Okay. All right, then I agree the conditions of release that I stated, as well as those suggested by Mr. Stover, will be imposed. And Mr. White, if you're able to post a bond and be released, those are the rules that you have to follow. If you do not follow those rules, I can have a hearing and revoke your conditions of release, place you back in detention on a no bond until the matter goes to trial or is resolved otherwise. Do you understand that?
Yes, sir.
You also, I'm going to have you maintain contact with your attorney at least one time per week so that you are aware of your court dates and preparation for trial.
Yes, sir, Your Honor.
All right, I will prepare the order on that as well. Mr. Stover, is there anything else?
There's nothing further by the state.
Mr. Shieldgen?
No, Judge, thank you.
All right, we're in recess. Thank you.